Wusstest du, dass Zehntausende deutsche Unternehmen bereits Shopify nutzen? Von innovativen Startups bis hin zu Familienunternehmen mit langer Tradition? Die Commerce-Plattform Shopify revolutioniert Millionen von Unternehmen weltweit. Mit Shopify kannst du Produkte über beliebige Kanäle verkaufen. Ob persönliches POS-System oder umfassende E-Commerce-Plattform. Auch Social Media und Marktplätze wie Facebook, Instagram und eBay werden unterstützt. Dank der ständig wachsenden Auswahl innovativer Funktionen und des zuverlässigen technischen Supports ist es ganz einfach, dein Business mit Shopify aufzubauen. Ob Produktpräsentation oder Bestell- und Zahlungsabwicklung. Shopify bietet alles, was du für die Verwaltung deines Business brauchst. So kannst du dich ganz auf dein Business konzentrieren. Shopify kostenlos ausprobieren und dein Business voranbringen. Shopify.de/try besuchen. Also shopify.de/try. Made for Germany. Powered by Shopify. Wünschst du dir jemanden, der dich versteht wie kein anderer? Jemand, der deine Wünsche wahr werden lässt und mit dir das schönste Abenteuer deines Lebens erleben möchte? Die Commerce-Plattform Shopify revolutioniert Millionen von Unternehmen weltweit. Mit Shopify richtest du im Nu deinen Online-Shop ein. Ganz ohne Programmier- oder Designkenntnisse. Dank der effizienten Einrichtung und intuitiven Social-Media- und Online-Marketplace-Integration kannst du über Instagram, eBay und Co. werben und verkaufen. Neue Zielgruppen zu erreichen war noch nie so einfach. Shopify bietet auf einer einzigen sicheren Plattform alle Tools, um dein Online-Business aufzubauen. Kostenlos testen und dein Business der Welt präsentieren. Shopify.de/try besuchen. Einfach shopify.de/try eingeben und loslegen. Made for Germany. Powered by Shopify.
Every Nigerian must be instrumental to the growth and development of our nation through the use of innovative energy and idea to lead and initiate policies that will sustain the economy and enhance good governance. With all the financial turmoil facing the world, it has become pertinent for exchange of new ideas that will enhance good governance. Please subscribe to our channels, listen to our messages and engage with us. With your support, we can transform the lives of all Nigerians. Welcome to the Season 2 of the NESG Radio.
Hi everyone, and welcome to another episode on NESG Radio. My name is Ogechi Obase. I'm an analyst with the National Assembly Business Environment Roundtable. On today's episode, we'll have with us Mrs. Diane Okoko. Mrs. Okoko is a notary public of Nigeria and an experienced arbitrator and legal practitioner with demonstrated practice experience. She is currently the principal partner of Marcus Okoko & Co. Mrs. Okoko is a member of the Institute of Directors and a fellow and approved faculty member of the Chartered Institute of Arbitrators, UK Nigeria branch, as well as a fellow of the Institute of Construction Industry Arbitrators. She is also a registered capital market solicitor in Nigeria and a member of the Governing Council of Janada International Center for Arbitration and Mediation, GCAM. She is listed on the panels of Neutrals of Nigerian Communications Commission, Abuja Chamber of Commerce, and Industry Dispute Resolution Center, Cairo Regional Center for International Commercial Arbitration, Lagos Court of Arbitration, and Abuja Multi-Door Courthouse. She is severally sought after to provide insights and advice on company law and practice in her role as company secretary, legal advisor to several boards and governing councils, multinational companies, government agencies, etc. Mrs. Okoko is a recipient of several recognitions and awards. Inclusive of them are the Global Group Media CNBC NBC sponsored feature on Africa Women Rising series. 31 Women Creating a Positive Impact in Africa, Young Professional of the Year by the Women on Fire Foundation, Award of Excellence, which was bestowed on her by the Law Students Association of Nigeria, University of Abuja, Award of Excellence for contributions to development of the youth by Government Secondary School, Karshi, Abuja, All Students Association. Mrs. Okoko is an alumna of the Wharton Executive Education Program of the University of Pennsylvania in Strategy and Management for Competitive Advantage. Mrs. Okoko is also the thematic lead for the NASBA Arbitration and Dispute Resolution thematic area. Welcome to this episode, Mrs. Okoko.
Thank you, Ogechi, and I extend my gratitude to the NESG for the kind invitation and for having me here.
Thank you very much, ma'am. I'm sure we'll have a very pleasant conversation with you today, and we'll tap into your wealth of knowledge. As I saw while reading your profile, you're very accomplished, if I may say so. Well done.
Thanks, Ogechi. Thank you.
All right, ma'am. You have a very long history in the practice of arbitration. Can you tell us a little bit about that? How did you begin? And how did you get to where you are in terms of becoming a fellow of the Chartered Institute of Arbitrators?
Okay, so my venture into arbitration was as a result of a conscious decision I took not to fully pursue the route of litigation when it comes to dispute resolution. And for me, it was as a result of what I had seen, during dispute resolution, the dispensation of justice, what the litigants, the parties faced, in terms of how long it took, how much of a snail speed there was. And in discovering arbitration and other forms of dispute resolution, I did realize that, certain kinds of disputes were better suited for ADR practice. And, I immediately told myself I was going to be one of the tools towards faster dispensation of justice, in the sense that if I had an option to advise on what route to take based on the kind of dispute, then I certainly would recommend arbitration or mediation rather than litigation. Because truth is, when parties are in dispute with each other, what is key is the dispute itself, not the parties, not the history. And most times, when it comes to businessmen, what they want really is to keep their eyes on the price, the profitability. Now, we all know about time value of money, right? So the longer the dispute lasted, the more their profitabilities were eroded. And so ADR offered that route to a faster dispensation of justice, in my view. You did ask about my getting to this point. I think it's a straightforward answer. As soon as I took the decision that ADR, arbitration, was going to be, the trajectory of my growth, I delved into it fully. So I did the entry course, I did membership, I wrote the fellowship examinations, all within a very short span of time, quite honestly. But I put in everything that I had into getting to becoming a fellow, and the rest they say is history, isn't it? Okay.
Yes, it is. That can only be described as having laser focus on a goal and hitting it. Kudos to you, ma'am. So we know that the president recently signed the Arbitration and Mediation Act 2023 in May. The act repealed the old Arbitration and Conciliation Act of 1988. As we all know, with old laws in Nigeria, by the time they are repealed, they would have caused some discomforts, if I may describe it as such, to both practitioners and parties. So in your practice, ma'am, what would you say were some of the challenges that you encountered still having the old law made in 1988 up until May 2023? What were the challenges you encountered on account of the repealed Arbitration and Mediation Act?
So generally, because we know that ADR is an evolving, area in Nigeria, and acceptance for it is still, awareness for the acceptance is still being galvanized, right?
Yes.
I'd say a major challenge that I encountered in the course of practice was as a result of the lack of awareness. That was one. And then secondly, a practical experience had to do with interim measures for protection. Because the tribunal in the old act was not empowered to grant these interim measures, recourse had to be had to courts. That kind of expanded the period for the whole process of the arbitration. The duration was longer because we're all very familiar with what the dockets in the court system is like. It's full. Before you went to a judge and got that particular interim right. So to get those interim measures of protection, you had to have recourse to courts. And the time it took to get that particular order granted was a bit of a stretch. For some arbitrations, it would erode even the essence of the arbitration. So things like those particular provisions that were not available in the repealed act managed to put a clog in the wheel of how fast the wheels of justice could churn. So I'd say, one of a major downside or a challenge that was faced with the repealed act was the grant of interim measures of protection by the tribunal itself.
Yeah. Oh, thank you very much, Ma. On the back of that, I was just going to also ask about the arbitral awards and having the court enforce it. I know that enforcement sometimes can be a challenge. So was that also occasioned by any provision in the repealed act in terms of not getting the arbitral awards enforced, just like a court judgment to be enforced?
Wünschst du dir jemanden, der dich versteht wie kein anderer? Jemand, der deine Wünsche wahr werden lässt und mit dir das schönste Abenteuer deines Lebens erleben möchte? Die Commerce-Plattform Shopify revolutioniert Millionen von Unternehmen weltweit. Mit Shopify richtest du im Nu deinen Online-Shop ein, ganz ohne Programmier- oder Designkenntnisse. Dank der effizienten Einrichtung und intuitiven Social-Media- und Online-Marketplace-Integration kannst du über Instagram, eBay und Co. werben und verkaufen. Neue Zielgruppen zu erreichen war noch nie so einfach. Shopify bietet auf einer einzigen sicheren Plattform alle Tools, um dein Online-Business aufzubauen. Kostenlos testen und dein Business der Welt präsentieren. Shopify.de/try besuchen. Einfach shopify.de/try eingeben und loslegen. Made for Germany. Powered by Shopify.
I wouldn't say it was as a result of any provision in particular, Ogechi. What I'd say is this. First and foremost, the stakeholders within the arbitral landscape, right? So who are these stakeholders? Counsel, the parties themselves, the judiciary, the acceptance that an award had was not as cogent or was not as the awards were not as highly looked at like a court judgment, but truth told, it ranks at par with a court judgment because an award actually is meant to be final and binding, right, on the parties. So it means that it had the highest authority of the backing that the parties gave to it. So you would find that aggrieved parties were very quick to run to courts to try to set aside these awards, and some members of the judiciary, again, because of the lack of, the knowledge of how arbitration works, saw instances where they could set aside or were very quick to set aside, forgetting what the provisions of the repealed act or even the new act says. There are very clear-cut grounds upon which an award can be set aside, okay? And it's very deliberate that those grounds are streamlined and those grounds are very clearly marked out. So a lack of awareness, a lack of knowledge would allow that the judiciary could go out of those grounds to set aside, even when there were clear-cut grounds as to when an award could be set aside. So I'd say not exactly the provisions of the Act, but more about stakeholder knowledge, information, and awareness.
Thank you very much, Ma. That was quite incisive. So it's been a long road to the passage and presidential assent of the Arbitration and Mediation Act, which we're well part of. So I'm going to ask, do you consider it a win for Nigeria's arbitration community, both practitioners and parties alike? And why would you say it's a win or if it's not a win?
Two hands up, Ogechi, for the fact that it's a win.
Okay. Two hands up. Okay, that's good.
Nigeria has now one of the most progressive pieces of legislation when it comes to arbitration practice in the world.
Wow, that's huge.
There are very, very few arbitration acts that can compare in substance with the Nigerian acts right now. You know, so, and the reason that this is not just a win for the arbitral community, but a win for the country as a whole is first and foremost, right? What do investors look at when they want to make an investment? They look at your judicial system. Beyond the viability of that particular investment, they look at your judicial system. In the event that there is a dispute, at what point is your judicial system going to be one that they can trust? In determining whether or not they can trust the judicial system, they are looking at what is the legal framework that judicial system rides on. So they look at the law, and if the law is not as progressive as they want it to be, then they're skeptical as to whether or not that ground is a fertile ground for investment. So it makes Nigeria, you know, a more friendly seat, because if you realize that the law, the arbitration law, which is the default dispute resolution mechanism for businesses, right, for investors, if the arbitration law is a progressive one, then one point checked on that checklist. Immediately that point is checked, then it instills investor confidence. The investors know that I can go here in the event that there is some dispute. There is a likelihood that the law is in my favor because of what the provisions of that law, you know, what the provisions are. And ultimately, you know, it would attract FDI. And at the end of the day, what every country is looking to do investment-wise is attract FDI, isn't it? So I'd say, this is a win for the country, definitely.
Yes, it sounds like a long list of wins, and I feel like if I didn't, or maybe if we're not going to move on to the next questions, you probably have a long list of items you would reel out from the Act as the positives. So I was just going to ask, so for you, what are the most innovative provisions in the Act? What are the most novel and provisions in the Act that mark a huge difference from what is obtainable in the repealed Act and in other climes?
Wünschst du dir jemanden, der dich versteht wie kein anderer? Jemand, der deine Wünsche wahr werden lässt und mit dir das schönste Abenteuer deines Lebens erleben möchte? Die Commerce-Plattform Shopify revolutioniert Millionen von Unternehmen weltweit. Mit Shopify richtest du im Nu deinen Online-Shop ein, ganz ohne Programmier- oder Designkenntnisse. Dank der effizienten Einrichtung und intuitiven Social-Media- und Online-Marketplace-Integration kannst du über Instagram, eBay und Co. werben und verkaufen. Neue Zielgruppen zu erreichen war noch nie so einfach. Shopify bietet auf einer einzigen sicheren Plattform alle Tools, um dein Online-Business aufzubauen. Kostenlos testen und dein Business der Welt präsentieren. Shopify.de/try besuchen. Einfach shopify.de/try eingeben und loslegen. Made for Germany. Powered by Shopify.
So this is a very good question. And if I were just going to give a one-line response, I would say everything is novel, but that will not be an answer you're looking for. So let's talk about certain specifics, right, as to novelty. First and foremost, arbitrator immunity, right?
Okay.
Arbitrator immunity in the Act is something that will not only help the efficiency of the arbitral process in this country, but will also give, confidence to arbitrators and the tribunal to actually do the work it has been set out to do within the professionalism that the tribunal knows to employ. Why do I say this? The bedrock of arbitration, one of the bedrocks rather, is equal opportunity for parties to present their cases, right? Equality and fairness, okay? Now, to what extent can equality and fairness be expanded? Because the arbitrator most times thinks about how far can I go to demonstrate equality and fairness, and at what point will a party, especially an aggrieved losing party, pick on that to try to set aside the award. So you find a lot of due diligence, due procedure paranoia, and then you see due process paranoia go stretches and stretches and stretches because the arbitrator says, well, the parties want this, I will go ahead. So it doesn't give the arbitrator that much control as the arbitrator could have had. So at this point where the arbitrator knows, look, I have the immunity against being sued, just like the judge enjoys when the judge is sitting over a case and is performing within the ambits of his limits of their professional duties. So that, for me, under Section 13 of the new Act is such a welcome addition to the Act. It is a new provision and it's so very welcome. Then let's look at the provision that allows for the appointment of an emergency arbitrator. So remember when I spoke about the interim measures of protection, one of those reasons for appointing an emergency arbitrator would be maybe to grant an interim measure of protection, for instance, to save the subject matter of the arbitration. So where a tribunal has not yet been fully constituted, a party can request for an emergency arbitrator to sit over certain things, even before the constitution of the substantive panel. Then let's look at the award review tribunal. So what this means is that the parties, where an award has been handed down and they're not very comfortable, or one of the parties is not happy with the award, they can actually ask for an award review tribunal instead of going straight to court. So you realize that an award is handed down and an aggrieved party tells you, you know what, I'm going straight to court. I'm going to try to set this award aside. The award review tribunal, on the flip side, would look at this award and try to fix the award, if you will, to the extent that if there is anything for fixing, that means, otherwise, the award review tribunal gives its award, and there is a time limit of 60 days within which the ART can give a review of that award. So the time limit is specified. It's not an open-ended thing, and that gives an indication to the losing party as to whether or not, if they even proceeded to court, this award will be set aside. So if you got a decision from the award review tribunal saying, look, this award is a perfect award, there is no reason that it should be set aside, you may be more comfortable not going to court anyway, because you imagine that the courts would uphold, the award. So why waste resources? Why waste time? And then lastly, let me talk about the powers of the tribunal to grant interim measures of protection. And the reason I'm talking about this is because beyond the Act giving those powers to the tribunal, the Act also specifies under Section 28 of the Act that order granted is enforceable regardless of where it is granted worldwide. This is so innovative in the sense that if I got an order to preserve a subject matter in Nigeria, for instance, and the arbitration is seated in Paris, the courts in Nigeria, right, would uphold that order from there like it was handed down even here in Nigeria. So remember I spoke about instilling investor confidence.
Yes.
Now, the investor knows, what, the courts in Nigeria would uphold this, even if I do not get the order
in Nigeria.
Oh yes. So it's very comforting to foreigners to know that the Nigerian client is ready and ripe to honor, to respect anything arbitration-wise, anything in quotes, anything that is legal, legitimate, and meets the laid down dictates of how an arbitration should go and what should be upheld.
Thank you very much. But that was quite enlightening. And you mentioned,
for want of time, these are just a few. There are quite a number of them.
Yes, the Act seems packed. You've mentioned 4 already, and it's not even among the more popular ones like the seat of arbitration and third-party funding, which everyone has been going on and on about. So, but wow, the Act, it seems like it's going to do a lot for investments in Nigeria. So I was going to ask next, what do you think about third-party funding? There's been a lot of opinions about third-party funding, and it's been or going to raise conflicting or malicious proceedings against parties. So, what are your thoughts on third-party funding? Do you think it's an important provision, or do you think it should have been left out?
Let me take your question, from the first you asked, which is whether or not it will, instigate malicious proceedings. And my response to that is no, not necessarily. Reason being that the Act itself, right, has made provisions for why this will not happen. And let me tell you why. Section 62, rather. So third-party funding is, provided for under this. 62, 1 and 2 tell you that the party being funded has to disclose first and foremost to the other party, to the arbitral tribunal, to the institution administering that arbitration, who the funder is. So you see, from the get-go, there is already, certain levels of disclosure and transparency. Because as soon as the funder is identified, you can hazard a guess as to whether or not there will be some malice why the funder is funding this particular arbitration, and then talk about how third-party funding works. So the funders usually will carry out a very stringent due diligence onto the viability or otherwise of the claim, even before they agree to fund, because third-party funding really is a business model. It's not because the funders want to are so keen on any party getting its right, or they love justice so much. No. It's really business for them. It's about the profitability of the venture they're going into. So they will, do their due diligence as to whether this particular claim is viable. A malicious claim would hardly be viable, right? Because you don't have the ingredients to prove the claim. It's really just based on emotions, sentiments, and malice. So there is a likelihood that such claims will be turned down. So quite honestly, I do not imagine that this will, instigate malicious proceedings. So I believe it's a good add-on. It's something well thought of, and it has been added there so that parties who genuinely have authentic claims will not shy away from the arbitral process because they are unable to fund.
Thank you very much, Ma. Just on the back of your response, I was going to ask, so can the arbitral panel, do they have the authority to turn down a funder? You mentioned that it can be it's a business model. Does it also mean that persons who have no interest in the case, apart from the financial outputs, can fund an arbitration just for the sake of taking part in the award? And can the arbitral panel refuse their request to fund an arbitration award?
Okay, so two questions in one. The first,
yes,
mostly your third-party funders are people who have no interest. People who have no, legal ties to the arbitration.
Okay.
So they're mostly independent organizations that have the job to just fund. They're probably akin to a bank where you go to borrow money.
Okay.
Okay. So all they do is just fund, and then there's an agreement as to what is paid back to them from the proceeds of the arbitration. This is the reason I tell you that they will do their due diligence, quite honestly, and it is very, very thorough. They delve deep down into the merits of the case, check to see whether or not they're just, putting their monies down the drain, or there is the chance of winning. And there are some third-party funders that tell you that when they have done their due diligence, there is a threshold. Even if they think that, there is the likelihood of a win, if that likelihood on their scale doesn't get to a certain percentage, they will still not fund. So some have, they have to have at least a 70% or an 80% chance of a win before they can fund. Right?
Yeah, that's true. Yeah.
Yes. So the second question, whether or not the tribunal can turn down, in my experience, no.
Okay. All right. They do not have the authority.
Oh, yes. Except, of course, there is a link, right, between a third-party funder and a member of the tribunal.
Okay.
So remember that there is the duty of disclosure in arbitration. where the tribunal has to disclose certain levels of relationship. So if that relationship were too close to the tribunal, then upon the disclosure, naturally you would find that the other party says, no. At this point, I will challenge this arbitrator and ask that the arbitrator step down because of the proximity of the relationship.
Yeah, sure. Thank you very much, Bob. So this act sounds like a knight in shining armor, if I may call it that. That has come to save the arbitration in Nigeria. So I was going to now ask, as good as the act sounds, and we know that law is dynamic, it changes as society progresses and innovations happen. So are there still areas of improvement that exist in the act? And would it be a problem in the near future?
So I think you've, kind of answered your own question. Because society is dynamic, there is the need, regardless of how beautiful the act is today, it may not serve the need or, adequately serve the need of the arbitral community in the next 30 years, right? So this is the reason that every law, regardless of how beautiful, how nice, how apt it is for the time, needs to be reviewed, right? But let me talk a little about how this act can serve us, especially in Nigeria, and serve us to the maximum. And I'll go back to awareness. A lot of awareness needs to be created within the whole value chain, right? Every stakeholder needs to be educated on their role in the implementation of this act. Counsel needs to be trained. They need to be taught. They need to be educated. Because truth is, regardless of how good you are as a lawyer, if you're a litigation lawyer, you need to learn how to be an arbitration lawyer, because they're two different ball games entirely, right? The judiciary needs to be educated. Awareness needs to be created there. And then the users of the arbitration process, the parties. It is our duty as, the promoters of this act to talk to the parties, to let them know what entails. Because let me speak as a lawyer now. You did introduce me as a lawyer, right?
Yes, ma'am, I did.
So I can speak as a lawyer now.
Yes, feel free.
What am I selling? The one thing I have to sell is trust.
Yeah.
My clients need to trust me. When they trust me, because that's the only thing I can sell, we don't have products to sell. The only thing we sell as lawyers, is trust. As soon as our clients trust us, there's nothing they will not take from us. So where I am not aware of the provisions of, how beautiful a legislation is that is available to help my clients, how can I advise them, right? So a lot, I say this without any, without ambiguity, a lot lies on the shoulders of the arbitrators themselves, counsel in arbitration, right? Because most times counsel in arbitration are the same counsel who are the drafters of this contract, who are the advisors of the parties that come to arbitration. A lot lies on our shoulders. We need to do so much awareness creation. We need to do a lot of stakeholder education.
Thank you very much, and you've answered my next question even before I got a chance to ask it. I was going to ask about the implementation of the act and what steps are being taken to ensure that the act is properly implemented, which you've gone ahead to speak about awareness, which I think is a very big point, because without awareness, people are not are unaware of the contents of the act and what role they have to play in its implementation. So are there any words left on implementation of the act?
Well, not really, because between both of us, I think we've just summed it up with, 2 words: stakeholder education.
Yeah, sure. Okay. My next question is around the arbitration process.
Mm-hmm.
In favor of ADRD, it's often been argued that it's not as strict as the court system. It's slightly informal. It's party friendly, and just generally better than the court system that takes a long time to produce judgments for any matter that comes before it. So, with all these procedures listed in the Act, in the Arbitration and Mediation Act, does it not bring it a lot closer to being as strict as the court system?
Okay, thanks for that question, Ogechi. So, arbitration rests on the fulcrum of party autonomy. So it's really about the consent of the parties. The parties can agree to do whatever they would like to do within the ambits of the law, right? So procedure, for instance, the proceedings, strictly party agreed. At the preliminary meeting, for instance, okay, so parties come and they tell you things like, you know what, because we're really busy, we wouldn't want to have meetings during weekdays. Can we have our sittings? Can we have a hearing on Sunday by 2 p.m., for instance, in so-so person's house, so that while we're having lunch? Do you understand? So the flexibility is there, right? So it makes it less procedural, it makes it less rigid, it makes it less strict, right? So really, arbitration is sense of the parties, whatever they agree to do. And then I go back to counsel understanding and knowledge. So if, one party says, or counsel representing a party says, Mrs. Okoko, can we have this hearing on a Sunday by 1 p.m. and the other party says, no, the rules of court say this, then you know that even at that point, there would be the need for an alternative dispute resolution mechanism, maybe a mediation or a negotiated settlement, even between the counsel, right? So as long as counsel understand, have the knowledge, trust me, it's such a fluid process. It's so informal, very flexible, right? So the Act just serves as a guidance and a framework within which the parties can work. Ultimately, it's about the party agreement. Ultimately, it's about what these parties want, right? So, quite honestly, no. This Act is not going to align or make the arbitral process akin to that of a court. No.
Okay, ma. I'm very happy to hear that the Act does nothing to the party friendliness of the arbitration process, because that's one of the major upsides of arbitration for a lot of parties. So I'll move on to enforceability of arbitral awards. We spoke about that briefly at the start of the session. So I'm going to ask, how does the Arbitration and Mediation Act address the enforceability of arbitral awards and mediated settlement agreements, since it's an Arbitration and Mediation Act?
So one of the beauties of this Act is that it has finally codified, the Singapore Convention for international settlement agreements, right? So Section 87 clearly states, right, that the any settlements under the Singapore Convention will be recognized in Nigeria as long as it emanates from a Singapore Convention country and it's in relation to a legal relationship, whether contractual or otherwise, actually, but it's recognized as a commercial transaction under the Nigerian laws, and it does same thing for the New York Convention under its Section 60, because very clearly what it has said is we recognize, we respect these two pieces of legislation. That's very progressive, because for the first time, especially for mediation, it has laid down very clear provisions as to, the practice of mediation in Nigeria. So I dare say that, quite honestly, you would find a tilt towards mediation, even away from maybe arbitration and especially from litigation. Because now there are guidelines, now there are provisions that are there within the law, sacrosanct, that parties can follow, and know that it becomes binding. The thing, Ogechi, is as long as the thing is reduced into writing, parties are better suited to follow.
Yeah.
They respect better when they see things in writing than when they imagine, regardless of what the agreement is, something has not been reduced into writing. So now that it's very clearly within the law, I am very optimistic that we would find a lot more mediations taking place in Nigeria, and then a lot more awards being upheld because of the codification of the New York Convention. Yes,
I join my faith with yours and hope that will be the case.
I'm not so sure it's a faith thing. I think it's an analysis of the trends. So if you did a trend analysis, you would find that, this is how things work. Once there is that recognition in writing, there's more confidence, there's more backing given to a particular kind of thing. So, and I think our arbitral community is on its toes now. It's doing a lot. Yeah. The courts, quite honestly, if I'm being honest with you, are being more and more progressive. And I will give kudos to institutions such as the Chartered Institute of Arbitrators for the kind of trainings that they're giving to the judiciary in particular.
Okay. All right. My next question is in terms of the usage of the Act itself. It may be too early to say, but are there any notable cases where the Arbitration and Mediation Act has been utilized recently?
Too early. This is a May piece of legislation. Okay.
Yeah.
Exercise some patience, and we will.
Okay. All right. We'll come back to it another time. So
very soon, I believe.
All right, well, you spoke about the impact of the Act on investment in Nigeria in terms of attracting investments in Nigeria. Yes. But what can be said about the influence of the Act in investment retention? Do you think businesses would stay back, or investments that have been attracted to Nigeria would remain or be retained in Nigeria as a result of the Act? And how beneficial do you think all of these would be to the Nigerian economy?
Okay, so you know that default for Nigeria when it comes to investment disputes is ISDS, dispute resolution mechanism, investor state disputes settlement mechanism, right? So because legislation such as the NIPC Act put it there as an automatic default mechanism, right?
Yeah.
So dispute resolution mechanism when it comes to foreign investments is under ISDS. Now, with us being signatories to AFTA. It now puts a tilt. But the investment protocol of AFTA is still being, it's not been released yet. It's still being negotiated. I imagine that before the year runs out, we'll be done with that protocol, okay? And hopefully that protocol will borrow some provisions from the Pan-African legislation. So we imagine that it will be a very progressive piece of legislation, okay, or protocol rather.
Yes.
But I do say this, and very, very confidently too, that because we have a law that allows Nigeria now to be an arbitration-friendly seat, we will see a lot of FDIs. We will see, the fact that foreign investors now see Nigeria as a place where their investments are protected to the extent that the law is on their side, right? And the reason I say this is because if you looked at that law, you know that when it comes to the seat of the arbitration and Nigeria is the seat, it means that the linkage to the procedural legal system would be the Nigerian legal system. And if Nigerian legal system is, the jurisdictional law that they will have to refer to, what is that law saying for them? When they see things such as this, then they are more confident. You know what? I'm going to put this investment here, and regardless, even if Nigeria is the seat of this arbitration, I am confident that to a certain extent, the law is on my side, because this piece of legislation is a good legislation for any foreigner to have confidence in.
Yeah. Thank you very much. But that perfectly answers the question as to investment retention. And I agree with you that anyone or any investor that it would imbue their confidence that the Arbitration and Mediation Act is on their side if any dispute arises. So again, we said earlier in the interview that the act sets Nigeria miles ahead of other countries. So, other countries will be playing catch up to us now. Is that so, Ma?
Yes. I say so. I remember I said that there is 2 hands up for this act.
Yeah.
Okay, very seriously. There are very, very few pieces of legislation that are this progressive when it comes to arbitration. Very few. So quite a number of countries are going to use the Nigerian Act as a model law, if you will, on redrafting their own
legislations.
Arbitration acts. So this piece of legislation is it may not be the best in the world, but it ranks at par with the very, very best of the legislations.
Oh, thank you so much, Ma. We've had such a long conversation, and it's been interesting, it's been fun, and it's been very, very educative and enlightening. So I'm just going to, any final thoughts on arbitration, on the act, on awareness, on implementation, and generally, any final thoughts that you may have?
Okay, so in closing, let me talk just about awareness creation and the arbitral community in general. So for awareness, we all must have our hands on deck, quite honestly, every single one of us, inclusive NESG. So everybody who is aware of this act must do their bit to reach, their own audience. The NESG, for instance, deals with communities that are business-oriented. What is the role that the NESG can play? The NESG can create awareness by putting the users this process in the same room, having talks with them as to conduct and embrace and how they can embrace this act. Truth is, if we all are on the same page as to, what this act can do for Nigeria, the fact that, arbitration is not in competition with litigation, rather, it's a complementary service it provides. If all were in courts, at what point will disputes be resolved? It means that half of the country will probably have to apply to be judges, right? Because of the amount of cases that will be heard. So, NESG can play its role. Lawyers need to be really fully on board with it. And I dare say, as soon as the lawyers are on board, parties are almost automatically on board, because the parties will listen to their lawyers, right? That's one. For the arbitration community, we must uphold the highest levels of integrity, the highest professionalism when it comes to the industry, so that we can rank at par with the topmost arbitrators worldwide. Because I know without a doubt that we have very good crop of arbitrators, counsel in arbitration in Nigeria, right? But we need to be seen and known for this. So, counsel in arbitration, integrity, integrity, integrity. It's not every single award you must rush to court to try to set aside. There are awards that are most of the awards are perfectly written. The rationale for these awards are top-notch. Do not rush to court because you need to prove to your client that you are doing their bidding, right? And then just prolonging the process. Arbitrators must have the highest level of integrity, competence, expertise, to compete very favorably with their counterparts around the world. We are doing this very well. We have the expertise. We have very competent arbitrators, and we're amongst some of the best in the world. So we need to show the world and let the world know that the work has been put in to get the act out. Let's now use the act and work with the act.
Thank you very much, Matt, for your final thoughts, which were equally loaded. And again, thank you for joining us on today's session on the NESG Radio. It was a pleasure having you here with us. And thank you to our listeners for sticking with us to the end. Mrs. Okoko, like I mentioned earlier, is a fellow of the Chartered Institute of Arbitrators and the NASBA thematic lead on arbitration and dispute resolution. Thank you once again, ma'am, and enjoy the rest of your day.
Thank you so much for having me, and it was my pleasure to be here with you.
Thank you, Ma. And for other resources to our listeners, please visit the NASBA website on www.nasba.org, and you find more information on the Arbitration and Mediation Act. Thank you very much.
Thank you for being a part of today's interesting program. You can learn more about the NESG's If Not Now When campaign at www.ifnotnowwhen.ng. You can also listen to other interesting conversations by visiting www.nesggroup.org/podcasts.